also associated with Justice K.S. Ramamurthy. He was designated as a senior counsel in the year 2005. He's been practicing in the civil and appellate sides. He's had several lecture sessions in the Tamil Nadu State Judicial Academy. I will request all of you to keep with you the latest book on Specific Relief Act that will help you to follow the lecture and shoot your questions at the end of the session. That's going to be after one hour. Thank you all. Now I request Mr. Parthasarathy with his lecture.
Thank you, Raghu, for the kind words. Before I commence the lecture, I request all participants for a minute silence for Sri S.V. Jayaraman, who passed away this morning. Okay. I take this opportunity to thank our senior T.S. Gopalan for giving me this opportunity to give a lecture. I'm audible? Yes.
Yes, sir, you're audible, sir.
Oh, I was just wondering. I thank Mr. T.S. Gopalan, Mr. Anand, Raghu, and others for giving me this opportunity to present this lecture on the recent amendment to the Special Relief Act 1963. My lecture will generally cover the Act as such and the law relating to special relief, with particular emphasis on the amendment in the year 2018. The amendment has come into effect, and as far as the proceedings with reference to special relief, we have to look into the provisions of the amended Act. And the amended Act has brought in several changes which are, in my view, very substantial. And during the course of the lecture, I will cover those amendments. To have a general view as to what is this law, all of you are aware of the principle, ubi jus, ibi remedium. Where there is a right, there is a remedy. Right is an interest recognized and protected by law. So any person having a grievance that he had been wronged or his right has been affected could approach the ordinary civil court on the principle of ubi jus, ibi remedium. There is no wrong without a remedy. The entire law of grievance redressal is based on the above principle. The maxim has a human right aspect also. Since access to justice is a human right, therefore, a party having a grievance must have a remedy. A man who has a right must have the means to vindicate, not only vindicate and maintain it, but also a remedy if he is injured in the exercise of or enjoyment of such a right. Of course, this right can be restricted and also substantially excluded by legislation, and only legislation alone can do that. Otherwise, the remedy is not barred. And in India, the jurisdiction of the civil court is enacted in section 9 of the Civil Procedure Code, and the principle ubi jus ibi remedium is exemplified by section 9, and the 9 is an enforcement of the fundamental principles of law laid down in the aforesaid doctrine. All of you know that law of specific relief is founded on the principles of equity enunciated by the courts of equity in England. One of the leading general principles of equity jurisdiction was to give relief when there is no adequate remedy in law, or for that matter, common law. So equity will fill in the gap. Of course, it cannot override the law, but it will fill in the gap when law does not give a remedy. Since the earliest instance of specific performance in India can be traced to section 192 of the Code of Civil Procedure 1859. Section 192 read as follows: when the suit is for damages for breach of contract, if it appears that the defendant is able to perform the contract, the court, with the consent of the plaintiff, may decree the specific performance of the contract within a time to be fixed by the court, and in such case shall award an amount of damages to be paid as an alternative if the contract is not performed. So this one section covered the entire law of specific relief from 1859. Then in 1872, Indian Contract Act was codified. So the legal right that arose originally on breach of contract as per the provisions of the Contract Act was a relief in damages. And this was provided even in the Contract Act under section 73, 74. And as time passed, it was found that the remedy of damages was inadequate, and equity courts evolved doctrines to provide reliefs in specie. So specific relief is a relief in specie. It is a remedy which aims at the exact fulfillment of an obligation. British India passed Specific Relief Act 1877, mark you, to define and amend the law relating to certain kinds of specific relief. This 1877 Act was drafted on the lines of the draft New York Civil Code of 1862. The main provisions of 1877 Act embodied the doctrines evolved by the courts of equity in England. These doctrines prior to the enactment had been applied in India. See, normally when there is no law, principles will be applied on the basis of equity, justice, and good conscience. So what in the circumstances of the case would do justice, and which is in accordance with the good conscience would be the correct thing to do. So all these principles were followed before the enactment. Then the enactment came in 1877, which codified the law and said these are the circumstances in which relief could be granted in specie. Then from 1877 to 1963, there was absolutely no new law. And after the advent of independence, the Law Commission of India recommended the promulgation of Special Relief Act of 1963. The 1963 Act envisaged 7 kinds of specific relief. Number 1, recovery of possession of property, immovable and movable, sections 5 to 8. Number 2, specific performance of contracts, sections 9 to 24. Number 3, rectification of instruments, section 20, rectification of instruments. Section 26, rescission of contracts, section 27 to 30, cancellation of instruments, section 31 to 33, declaratory decrees, sections 34 and 35, and last, injunctions, sections 36 to 42. As the preamble of the Act would indicate, it is an act to define and amend the law relating to certain kinds of specific relief. It does not lay down the law relating to specific relief in all its ramifications. But of course, on the matter on which the Act defines the law, it is substantive, it is exhaustive. Now that it is not exhaustive as of the whole branch of specific performance has been held in Hungerford Investment Trust Limited vs. Haridas Mundra, a case reported in 1972, 3 Supreme Court cases 684. Though the Specific Relief Act is based on English law, there is a difference between English and Indian law so far as specific performance is concerned. In India, by virtue of the aforesaid enactment, it can now be considered to be statutory in nature, whereas in England, it continues to be within the domain of equity. Now, what does specific performance do? It compels a person to perform his obligations, either contractual or statutory, in specie. Now, I told you that specific relief or the Act is not exhaustive. For instance, if you take law of injunctions, the law of injunctions are not confined only to section 36 to 42 of Specific Relief Act. There are several other enactments like section 135 of the Trademarks Act 1999, section 108 of the Patents Act 1970, section 55 of the Copyright Act of 1957. These are all some of the provisions which deal with also injunctions. And again, the Act deals with equitable remedies because it is a codification of the equity principles that obtained in England, as opposed to common law remedies. Again, except for previously as certain provisions with reference to section 25, the Act was not compensatory in nature. The relief was not oriented towards compensation, and it was inconsistent and generally an alternative to compensatory relief. Now, as far as where it is complementary to compensatory is dealt with in section 21 of the Special Relief Act, and that has undergone a little change. I will come to it when I come to the amendment. Law is essentially, this law, as we have all seen all these days, is essentially a rule of procedure, and it was only considered to be a form of judicial redress. With this background, what kind of breaches are capable of remedy under the Act? See, when you take obligations, the obligations can be divided into two, negative and positive obligation. Breach of negative obligation gives rise to relief of injunction. Breach of positive obligation gives rise to specific performance. Injunction is also a specific relief. Specific performance is also a specific relief in specie. Injunction, by injunction, you are curing the breach or somebody who is trying to breach an obligation. Now, prior to the year 2018, Section 10 of the Special Relief Act had an explanation which enjoined the court to presume that compensation in money was adequate relief when the article was not of special value or interest to the plaintiff or was not an extraordinary article. And in fact, normally the rule is with reference to immovable property, compensation in money was never considered to be an adequate relief. One of the important, when I deal with amendments, you will see that Section 10 has also undergone a fairly important amendment, and we will see it shortly. And as I told you, that specific relief you can also find in other enactments like Transfer of Property Act, which deals with specific remedies in relation to mortgagors and mortgagee, the Partnership Act, with specific remedies available to a partner like dissolution, accounts, etc. And in fact, even the Civil Procedure Code deals with administration by creditor, Form 41 to 46 and 49 of Appendix A. This is also again a special relief. Execution of trust. So these remedies are different in origin, and therefore, except under Section 11 trust, these are not included in the Special Relief Act. And of course, you would have also come across several special laws like Consumer Protection Act, which gives specific reliefs like removal of deficiencies, replacement of defective goods. They will be governed by provision of the said law. Then, and another instance where directing reinstatement of a dismissed employee is governed by labor legislations. But these law or the statutory law is not in any way whittled down by the Special Relief Act. So let us understand what an obligation is. Obligation is any duty enforceable by law, and this excludes imperfect obligations. Obligation is a tie or bond which obliges one to do or suffer something. Imperfect obligations can be classified as moral, religious, or social. These are all obligations which are not enforceable by law. Obligation may arise out of a contract or tort. Obligation may arise out of trust. It will also arise out of a statute. Now to have an idea of what the obligation is, an easier way of looking at it would be, immediately we can take to section 38 of the Special Relief Act. See, if you take section 38, you will get an understanding. Subject to other provisions of contained in or referred to by this chapter, a perpetual injunction may be granted to the plaintiff to prevent a breach of an obligation existing in his favor, whether expressly or by implication. So, the entire law with reference to special relief is with reference to breach of an obligation. And if you see the definition of an obligation under the Act, obligation includes every duty enforceable by law. So when you read this Act along with the definition of obligation, every duty enforceable by law is capable of redress under the provisions of the Special Relief Act. And this obligation is not restrictive just to contracts. It can also include every other duty enforceable by law. In fact, if with reference to settlement, you have provisions under section 15 subclause E of the Act and also section 25 of the Act. Section 25 of the Act, any obligation entered in where a will is executed and the executor is asked to do something or give something, such an obligation which is entrusted to the executor is capable of being redressed under the Act. That you will see under section 25 of the Special Relief Act. Of course, the will or codicil is excluded from the definition, but section 25 says for a direction in a will or codicil to execute a settlement. See, if there is a direction in the will to execute a settlement, so long as the settlement is not executed as directed by any party interested under the will, may sue for specific performance of the conveyance. This includes even section 15 subclause C, marriage settlements. Then as regards trust and trustee, you can see section 11 of the Special Relief Act. When the duty is wholly or partially of a trust, even, of course, the power of the trustee cannot act in excess of his power. That would be, any breach in trust cannot be enforced. But supposing if a trustee has to act in a particular manner and he does not act, then he can be made to act in the manner as per the provisions of the trust created. Now, before you read this Act, you will have to keep in mind how the words, several words used in the act will have to be interpreted, or the meaning should be deduced. The words and expressions used in the act but not defined under the act will have the same meanings as assigned in the Contract Act. You will also find a similar provision in the Transfer of Property Act. Thus, the words used in the Special Relief Act, like agent is used in Section 8, subclause A. Then that the same meaning that is given under Section 182 and 238 of the Contract Act. Contract is used in Section 9. That gets its meaning as per Section 2, subclause E of the Contract Act. Principal, you will find that word principal in Section 15, subclause B. Again, 182 and 238 of the Contract Act. Then you will find expressions of fraud, misrepresentation, and mistake. Then consideration. All these things as per the provisions of the Contract Act, Section 18, 17, 18, 20, 22, 72, and 20 of the Contract Act. Whether it is void or voidable, again, you will have to only look into the substantial provisions in Section 31 of the Contract Act. So these words are not defined in the Special Relief Act, but defined in the Contract Act. Section 4 of the Transfer of Property Act provides that the chapters and sections of that act which relate to contracts shall be taken as part of the Indian Contract Act. Thus, by implication, those definitions would also apply to ascertain the meanings of the Special Relief Act. Now, as I told you even in the beginning of the lecture, the legal right originally available for breach of contract was a claim for damages, and Section 73 of the Contract Act provided for the remedy. Over time, the relief of damages was found to be inadequate, and equity courts granted specific performance. And the Specific Performance Act gives you an option either to seek relief of performance of the contract in specie or go for damages. Now, with reference to the contract, see, since my entire discussion today is going to be only on the specific performance of contracts. Specific performance of contracts, you have to see whether the contract has to be a written contract. It also says the contract need not be written. Even if it is written, it is not necessary it should be registered. And the contract can also be oral. Even an oral agreement could be enforced. And as far as registration is concerned, Section 3B of the Special Relief Act clearly says the provisions do not affect registration law. But however, there is a little change when it comes to, see, when you read Section 53 capital A of the Transfer of Property Act, Section 53 capital A of the Transfer of Property Act deals with part performance of a contract. Part performance of a contract after 24/9/2001, as far as Tamil Nadu is concerned, or rather, there was an amendment to the Registration Act on 24/9/2001. If any person desiring to get protection under Section 53 capital A, then such an agreement has to be necessarily registered. The previous requirement was it should be only written, not registered. Now it has to be registered. And this is only with reference to protection under 53 capital A and does not extend to enforcement of the contract. The contract could be enforced and the agreement can be enforced to get a regular sale deed executed. But if you want to rely upon it for the purpose of protecting your possession, then it has got to be registered. Because as you know, when they amended, they brought in 17 capital A to the Registration Act, but 49 proviso was not amended. 49 proviso permitted unregistered documents to be received in evidence of a contract to transfer immovable property. And it is not only Special Relief Act which gives a person who has been refused a sale deed, he can also proceed under section 77 of the Registration Act. But that remedy is not very comprehensive, whereas a suit for specific performance is more comprehensive and of wider amplitude. You have to also notice one important distinction with reference to agreement of sale in English law. In English law, the purchaser in a contract of sale of real property is made the owner in equity from the moment of the contract. This doctrine has no application in India. Section 54 of the Transfer of Property Act expressly declares that contract of sale of immovable property does not create any interest in the property. The question of equitable ownership of the buyer or trusteeship of the vendor under an agreement of sale does not accordingly arise. Any contract of sale which is not a registered deed of conveyance would fall short of the requirements of Transfer of Property Act. It will not confer any title, not transfer any interest in an immovable property. See, of course, you will find that contract for sale does not by itself create any interest in land. But however, the fiduciary character of personal obligation created by a contract of sale is recognized in the Special Relief Act and also in section 91 of the Trust Act. If you see section 91 of the Trust Act, I will say how it is recognized in Special Relief Act before. Let me draw your attention to one provision in the Indian Trust Act. Property acquired with notice of existing contract. Where a person acquires property with notice that another person has entered into an existing contract affecting that property of which specific performance could be enforced, the former must hold the property for the benefit of the latter to the extent necessary to give effect to the contract. This is precisely what is our section 19 subclass B of the Special Relief Act. Now, if you see even Transfer of Property Act section 40, burden of obligation imposing restriction on use of land. If you see that provision, where a third person is entitled to the benefit of an obligation arising out of a contract and annexed to the ownership of immovable property, but not amounting to interest therein, such right or obligation may be enforced against a transferee with notice thereof, or a gratuitous transferee of the property affected thereby, but not against transferee for consideration and without notice. This is precisely your section 19 or the Special Relief Act. So the substantive law with reference to section 19 can be found traced to section 90 of the section 91 of the Trust Act and also to section 40 of the Transfer of Property Act. Now you see, now with reference to so if any person purchases a property knowing that property is encumbered by an agreement, an earlier agreement, then he holds the property in trust for the agreement holder, the earlier agreement holder. Now, any intending purchaser who has been put in possession can protect his possession under section 53, capital A of the Act. And so in this background, let us now study some of the provisions of the Act. And as I told you in the present lecture, I will deal with chapter 2 of the Special Relief Act relating to special performance of contract. Now let us analyze the provisions, some of the provisions, and major changes were made only in chapter 2 of the Act. And the main reason for these amendments especially was to allow, or rather permit, an ease of doing business. You see, according to probably the government felt that they needed a new law to allow infrastructure projects to be completed on time, which will aid economic development. That seems to have been the main aim for making amendments to the provision, some of the provisions of the Act. Or if you see the provisions, if these amendments, they have concentrated more on this aspect, and to a great extent, it has some of the beneficent provisions of the earlier Act have been amended, with the result, in my view, a common man has not been taken note of. See, I can understand business houses, you have to promote. What has happened here is, this in my view, this is only a legislate, as usual, you legislate in haste and amend at leisure. That is what is going on. This is a legislation, in my respectful submission, has been made in haste. If you now look at the provisions of the amendment, and now this amendment was on 1st of August 2018. It has also been notified in October 2018. So now this has become the law, which the courts will have to grapple with and enforce in time to come. So while our predominant discussion on that aspect is going to be whether the provisions of these amendments, is it going to have a prospective operation or a retrospective operation? Will it affect pending proceedings? All these things will have to be studied. So let us first glean what are the substantial amendments, and then we will go into a discussion on that aspect. See, since I said that I'm going to only take up performance of contracts, I am not dealing with amendment to section 6. Of course, that is only very trivial. Now let us see the substantial amendments. What are the substantial amendments to section 14 of the Act? Before that, to just have a broad understanding what happens in proceedings in specific performance, you see how the Act is designed. If you see, it contains three parts. Part 1 talks about the definitions, the commencement, then what saving clauses under 3A and 3B, for special relief to be granted only for enforcing individual civil rights and not criminal wrongs. Then part 2, chapter 1 deals with recovery of possession of property. Chapter 2 deals with specific performance of contracts. Chapter 3 with rectification of instruments. Chapter 4, rescission of contracts. Chapter 5, cancellation of instruments. Chapter 6, declaratory decrees. Then part 3, preventive reliefs, injunctions and perpetual injunctions. So now we are concerned only with chapter 2, specific performance of contracts. As far as specific performance of contracts, the Act commences. I've gone through, not here. Am I there? Chapter 2 commences. Am I audible?
You are audible, sir. Please continue.
Chapter 2 deals, if you see section 9, it straight away starts with defenses respecting suits for relief based on contract. So first, they speak of defense. What are the defenses that are open? Defenses except as otherwise provided herein, where any relief is claimed under this chapter in respect of a contract, the person against whom the relief is claimed may plead by way of defense any ground which is available to him under any law relating to contracts. You know what kind of defenses? That is, main defense would be free consent. The agreement is vitiated, there is no free consent, there is no consensus ad item, there is no contract. It is vitiated by fraud, misrepresentation, undue influence, coercion, then impossibility of performance. Contract is illegal, opposed to public policy. These are all defenses which are available to any contract, are also available as defenses in a suit for specific performance. Then section 10, if you see the old Act, section 10 deals with specific performance in respect of contracts. The specific performance of a contract shall be enforced by the court subject to the provisions contained in subsection 2 of section 11, section 14 and section 16. Now, what was the section prior to the amendment? Section prior to the amendment, if you see, except as otherwise provided in this chapter, the specific performance of any contract may in the discretion, this will also you will find in section 20, may in the discretion of the court be enforced when there exists no standard of ascertaining actual damage caused by the non-performance of act agreed to be done. So when these provisions have now been amended, have been removed. So what is the effect of this? The effect of this one. That is, irrespective of the fact there exists any standard for proving actual damage, specific performance has become the rule. These differences with this is something which can be quantified, this loss as this breach is no longer open to you because of the amendment. And that is even with reference to, now with reference to both movable and immovable, it has become almost the same. At least with reference to immovable property, there was a presumption that compensation in damages is not an adequate remedy. So with reference to now, that has become blurred. And another important aspect is even the explanations have been removed. That is, because the explanations have now become unnecessary also in view of the fact that A and B has been removed. So what remains is specific performance in respect of contracts. The specific performance shall be enforced by the court subject to the provisions contained in subsection 2 of section 11, section 14 and section 16. So how will you view? See, previously the entire thing is specific performance or specific relief act is a procedural enactment. If it is a procedural enactment, will it have a retrospective operation? Or because having regard to the fact that when you enter into a contract, this was not the law. So persons would have entered into the contract on the basis of the law that was available on the date when they entered into the contract. Now when it comes to enforcement, the law has changed. So how to sort of find a via media to this? Whether we should make the provisions of the new act applicable to contracts prior to 2018, or it will apply only to contracts after 2018. These are all the difficulties which we now pay. So I will, with reference to it is generally in my view, I don't know, unless because we have not so far had an authoritative pronouncement of our High Court, or for that matter even Apex Court. But some of the two other High Courts of Allahabad and Calcutta High Courts have taken the view that these amendments are retrospective and it will apply to pending proceedings. Be that as it may, but let us now try to analyze these provisions and come to our own conclusion, leaving it to the courts in future to decide. Now, with reference to these amendments, if you see the policy underlying the Special Relief Act of 1963 was one of damages as the rule and specific performance as an exception, because most of the provisions both under section 40 and also under section 10, read with section 20 and also section 20 would indicate that specific performance was only an exception and damages was the rule. That in my respectful submission has undergone change. And what is that change? Now I have read to you section 10. Now you take section 14. Section 14 again, substantial changes. You see, if you see now the unamended section 14, you will find the following contracts cannot be specifically enforced. Namely, a contract for the non-performance of which compensation is an adequate relief. Now that has gone. A contract which runs into such minute or numerous details, or which is so dependent on the personal qualifications or volition of the parties, or otherwise from its nature is such that the court cannot enforce specific performance of its material. Even that is gone. See, if you see the amendment, I'm able to see the wry smile on Raghu's face. And a contract, the performance of which involves the performance of a continuous duty, which the court cannot supervise, is retained. But minute or numerous details of which is so dependent on the personal qualifications or volition of parties. What would be the effect on a contract with reference to service? Because the previous law, entire previous law has been that a person, there is a breach of a service, contract of service, then the courts were only granting damages but not reinstatement. Now, what would be the effect of this new amendment? The following contracts cannot be specifically enforced. Will you put it under section 14 subclass D? A contract which is in its nature determinable, because it will come squarely only under 14B, read with section 41 subclass E of the Special Relief Act. You see the reference to 41, you know 41E. To prevent the breach of a contract, the performance of which would not be specifically enforced. Supposing if, what is the effect of the removal of 14B, old 14B, which is so dependent on the personal qualifications or volition of the parties, or otherwise from its nature is such that the court cannot enforce specific performance of its material terms. All you have is, which involves the performance of a, you see, with reference to employer-employee, the court is not performing any continuous duty. You can simply put the employee back into service if the employee wants it. Could this be the result? It's all something which one has got to ponder, and only we'll have to work on these lines. This is with reference to section 14. You see, another important amendment which will also affect building contracts. You see, under old section 14, there was a provision, notwithstanding anything contained in clause A or C or D of subsection, the court may enforce the specific performance of the following cases. If you see building contract, the defendant has, in pursuance of a contract, obtained possession of whole or any part of the land on which the building is to be constructed or other work is to be executed. By reason of this new amended provision, you won't find this, this provision in the new act. So what is to happen with reference to building contracts, which was available for specific performance earlier? They are no longer available under the amended code, amended sections. Then let us go to section . As far as section 15 is concerned, there is not much of an amendment. Only the limited liability partnership had come into effect, so therefore only a new provision was included. Of course, another major amendment comes in section 16. Specific performance of a contract cannot be enforced in favor of a person. Of course, that is by virtue of section 20, I will come to it, substituted performance. So that was included, and who has become incapable of performing or violates any, that is retained. But what is now, previously it was, if you see subclass C, there must be an who fails to aver and prove. Now it is sufficient if you prove. Averment is not necessary. See, in so many cases they would not have averred in the pleading that they have been ready and willing. And that used to be a defense open to the defendant. But no longer lack of plea is a defense. And of course, to some extent, this amendment goes against the elementary principle of law that no amount of evidence can be looked into on a plea not raised. So evidence can be looked into even without a plea. This goes against the elementary principle. And section 20. Section 20 is again a wholesale. And in fact, in section 19, only the subheading after section 19, the heading itself was changed. Previously, discretion as to decreeing specific performance has now become substituted performance of contracts. That is the new heading. The previous heading was discretion and powers of court. That has become substituted performance of contracts. Section 20. substituted performance of contract without prejudice to the generality of provisions contained in the Indian Contract Act. So, if you see section 20 and section 10 and 14, substantial amendments have been made. So, can you still say that this act is not a substantial piece of legislation, but is only a procedural piece of legislation? In my respectful view, you cannot henceforth say that this is a procedural piece of legislation and therefore it has got to be given a retrospective operation. And if you, for that purpose, how the interpretation will have to go, you see now, this principle of procedural enactments being retrospective in operation, the Supreme Court in 2012, 4 Supreme Court cases, 253, N.K. Bajpai versus Union of India, has held that in determining the retrospective application of an enactment, the classification of the statute as either procedural or substantive will not be determinative whether it has retrospective operation. So they say the fact that it is procedural or substantive is no longer determinative of whether the act is retrospective or prospective. So therefore, in my view, the treatment of Special Relief Act of 1963 as an adjectival law will not by itself be determinative of the operation of the amendments as retrospective. One can argue that provisions have been substituted whenever legislation does not speak of the operation of the act, whether it is retrospective or procedural. It has to, when the act is substituted, it gets substituted from the date of the enactment and not subsequently when it came into force. So it has to be read into the act as if it was there as before. But this has been the general view. But as far as these amendments are concerned, we'll have to view the amendments. And in fact, when Section 28, Raghu knows, Section 28 of the Contract Act was amended with reference to forbearance to sue, legal proceedings. The Union of India versus Indus Bank Limited, 2016, 9 Supreme Court cases, 720. Justice Nariman, while deciding the operation of Section 28 of the Contract Act for the benefit of US Union of India versus Indus Bank Limited, 2016, 9 Supreme Court cases, 720. Justice Nariman, while deciding the operation of Section 28 of the Contract Act, 1872. See, the 1872 Act was amended only in 1997. Has come to the conclusion, a remedial act which is not clarificatory or declaratory of the law cannot affect the rights and liabilities that have already accrued as a result of agreements entered into between the parties. So, in my view again, these substantial changes which have been made can have only a prospective operation. Of course, there is also another view that is possible. Can we judge it on the touchstone of being retroactive? Whether the amendments can be made applicable to contracts entered into prior to the Act, but suits instituted after the Act. Now, you see, as far as the the Binami provisions were concerned, when the 1988 Act came, the Binami provisions were made applicable to pending suits. And that was the case law which was decided in Mithilesh Kumari, 1989, two Supreme Court cases, page 95. But of course, this judgment was overruled in R. Rajagopala Reddy versus Padmini Chandrasekharan, reported in 1995, 2 SCC, page 630. In Rajagopal Reddy, the Supreme Court said the provisions of the Binami Act will apply to transfers prior to the Act, but only from the date of the Act. The Act will not affect suits that were pending on the date of the Act. So it can also be argued that the provisions of the Special Relief Amendment Act 2018 may apply to contracts prior to the Act, but only from the date of institution. And in fact, even in Ardeshwar H. Mama versus Flora Sassoon, AR 1928 Privy Council 2008, interpreting the provisions of Section 1877 Act, the Privy Council said that the said Act is both substantive law and practice. So when 1877 Act could be substantive law and practice, why not Special Relief Act of 1963 as amended in 2018? So as the law stood prior to the amendment, the plaintiff seeking relief must first satisfy the court that normal remedy of damages is inadequate. And in fact, there is as I told you, there is a presumption in cases of contracts or transfer of removed property. Damages will not be adequate. So all these well-settled doctrines and principles have now been totally obliterated. Now we'll have to look at fresh into these provisions and work out our remedies. Now, this is with reference to the applicability of the Act. As far as special performance is concerned, we have seen the provisions of, you see normally how a contract is made: offer, acceptance, consideration, the object of which should be lawful. So once a contract is made, the promisor does not perform the contract, the promisee gets a right. And previously, you know that just because one of the contracting parties is not able to get performance, it will not mean that the other party will not. It mean mutuality. It will be very interesting. Again, I don't know why this was. You see, at a section 20, subclause 4, if you see section 20, subclause 4 of the 1963 Act, the court shall not refuse to any party specific performance of a contract merely on the ground that the contract is not enforceable at the instance of the party. You will know that this provision is also now removed. Under the new enactment, when they substituted a new section 20. The subclause 4 is not there. So are we to assume that defense of absence of mutuality can be now raised? So these are all the questions that one now has to face. Then as far as, you see, once before you draft a plaint for specific performance of a contract, what are the essential aspects one has got to look into? One has got to look into what is the nature of the contract, see the agreement. What is the agreement? What are the promises undertaken and who has undertaken such promises and how the contract has come into being. Then what is the consideration? What is the advance? What is the balance of sale consideration? Whether any time is prescribed for the performance. What are the time periods within which? So when you ascertain all these things and you come to court, then you'll have to see whether the suit is in time. And Article 54 of the Limitation Act is the act which governs a suit for specific performance. So Article 54 of the Limitation Act sets out the limitation for a suit for specific performance. The period available for filing a suit as per Article 54 is 3 years from the date fixed for the performance, or if no such date is fixed, when the plaintiff has noticed that performance is refused. So if no time is fixed, it is for the courts to arrive at the finding as to when the plaintiff had noticed that performance was refused. So interpretation of the term date fixed for performance. See, sometimes no date will be fixed, but within a few months. That's what it will be. Or it will be indicated by reference to that it will not be a crystallized notion. So you'll have to look into the agreement and see whether any date is fixed or it is being capable of making a definite date. And once that date is made definite, within 3 years from that date. If no date is fixed, there is no problem. Once when performance is refused, you can. But can you endlessly wait? Because in equity, delay defeats equity. So any remedy in equity, one has got to come to court within a reasonable time. So within reasonable time, without any delay. Maybe you may be within the period of limitation. That's why I said, but the English law, there was no limitation, but we have a limitation act. See, so therefore, previously the law was that even though we have 3 years to file a suit, by reason of whether you have delayed the matter even after to perform your part of the contract, then the performance could be refused. And now, with reference to the nature of the decree, that will be, as far as defenses that are open to specific performance, is all the defenses that are permitted to you under the provisions of the Contract Act are available. That apart, with reference to readiness and willingness is a requirement under Section 16, subclause C of the Special Relief Act. So you want any person who desires the court to give him a relief has to be fully ready and willing from the date of the contract till the performance. And he should not leave anything unperformed on his part. So when these things are clear, when readiness and willingness is established, now it is for the defendant to show that the contract is vitiated or that he was not ready and willing. Time is the essence of the contract. And ultimately, when a decree is passed for specific performance, what does it do? It directs the defendant to execute a regular conveyance. If he does not do, then the court itself will execute. And most of the decree will have to direct the contract to be specifically performed And the one important aspect which you have to keep in mind is specific performance decree is not like any other decree. It does not terminate the suit. The court passing the decree retains control over the decree even after the decree is passed. You may refer to section 28 of the Act. Section 28 of the Act is supposing if the decree directs that the balance of self-consideration will have to be deposited within such and such time. And there is a default. The person, the purchaser can approach the court under section 28, giving some reason for extension. The court can extend, but you will have to apply to the same court which passed the decree. And the court can also, at the instance of the defendant, can rescind the contract and dismiss the suit. So these are all available under section 28 of the Special Relief Act. And how to execute the decree? Provisions of Order 21, Rule 32 or the Civil Procedure Code is the manner in which specific performance could be enforced. So the principle is ibi just ibi remedium. Now I hope I have in the time allowed, I have done whatever that I threw open the. Is there any question? We can have a discussion.
Please go ahead.
Who is coming up?
Panchapakesan Sundaram Subramaniam. He says, whether the amendment taking the judicial discretion is valid as right to property is a constitutional right.
It's a constitutional right under Article 300A. But question of, you see, even there are so many aspects. Right to property is again a human right. In my view, this amendment takes note of only one aspect, that is ease of doing business. It has not taken note of the common man. And I am not, see, with reference to the constitutional aspect, whether it is ultimately the remedy is available only to the civil court. If such a remedy is not available and such a discretion is not given to court, that will offend Article 300A.
But then don't you think
Yes.
that a remedy can be restricted instead of an expansive remedy? There can be a restricted remedy. As long as you have a remedy, you don't have a right to complain. The remedy is restricted or regulated.
What you say, Raghu, with reference to when do you give a discretion to the court? What will be a position if you don't give any discretion at all to the court? You don't give any discretion to the court. This is the rule. And anything can be, see, anything can be a rule. You do it, that's all. You see, previously, supposing even if it is inequitable to perform, now the contract has got to be performed. You see, if the entire discretion goes, you see, person who holds the property is also has to part with this property. So therefore, I think the legislation is a legislation in haste. This is my humble view.
No, if there is, when you say equity supplants the law, does not supplant the law but supplements the law. here is a law which says that only certain types of equities are recognized, and I don't propose to recognize. I want to amend the recognition already given.
That is the rule. Equity will always give place to law. Once law has come in, whatever be the law, whether it is harsh or... but can you make a harsh law? You cannot. It's not like... see, it's almost like it's not a penal provision. After all, we are before a civil court.
Law of property. Property is not no more a fundamental right. It's only a constitutional right. And if you are staking your property by incorporating clauses, aren't you supposed to say, okay, these clauses I modify, alter because of certain by expediencies, because of public policy? Is that not right?
That has got to be tested. Not similarly, you, as you say, in banking legislation, you brought in SARFAESI, you brought in recovery of banks due there. So all those acts have been upheld. Similarly, if suppose it may not stand a constitutional challenge, but I'm only saying that the provisions are harsh. Or now
there's one more question.
Now, Raghu, manifest arbitrariness is a ground to strike down a legislation. So we can still test it on that.
What is arbitrary? Once again, depends upon the perception at that time. Public policy.
It depends on the court.
Yes. There's one more question. This is by Mr. Suresh Kumar. When the agreement not to be concluded, the other party can claim damage straight away or need to file a suit for specific performance.
When the contract is not concluded, there is no agreement.
Yes.
Where is the question of relief?
Relief. Is there any other question which any participant wants to shoot at the senior advocate? Advocate Suresh Kumar online. He wants to talk to you.
Oh. Where is he? I am not able to see him on the screen.
Mr. Suresh Kumar, please speak up.
Sir, can I speak to now, sir?
Yeah, please go ahead.
Sir, when the contract, the agreement itself is not to be executed because the property was sold by him another person.
Well, I follow you, Suresh. Just 1 minute. Yeah, tell me.
Sir, when the seller intended to sell the property, before concluding the agreement, he was sold the property to another person. So the purchaser has to file a suit for specific performance, or he straight away file a suit for damages.
1 minute.
Because there is
First, one thing, Suresh Kumar.
Yes, sir.
You are saying that the contract is not concluded.
Yes, sir.
If contract is not concluded, if there is no consensus added, if there is no regular contract, how will you enforce? You cannot file a suit asking him to enter into a contract. Agreement to enforce an agreement is not possible. Supposing if the contract is concluded, offer, acceptance with all the terms, there is a concluded contract, and the person, the promisor, does not effectuate this concluded contract, the remedy that is available to the promisee is to approach the court for performance of that contract. It is not necessary that he should sue for damages. Supposing if he is satisfied with damages, it's a different thing. And of course, if you see the new Special Relief Act, section 25 for a minute, if you see, not 25. If you see 21, section 21. The new section 21 power to award compensation in certain cases.
Yes, sir.
Apart from, with reference to specific performance, you can also get compensation for the breach as per the provisions of section 21. So not only specific performance is permitted, but also compensation. How you, supposing if you compensate, what is specific performance? It is only whatever that has got to be performed in specie, you perform. That is the best way which the contract could be satisfied, fully performed. Damages is again only a for prayer. Now, you see, when I was in the, this thing, I did not go into section 20 and the infrastructure contracts. One principle there is, now the entire provision of section 20 was amended only to aid ease of doing business, and the infrastructure project should not, and there is a separate schedule given where the infrastructure projects are mentioned. And in fact, the section 20 capital C also provides special courts for infrastructure projects. And section 1 says there cannot be any injunction with reference to infrastructure projects. So these are all new amendments which have come into force. But in fact, as Mr. Parthasarathy asked, this provision of special act, again, so many other special courts have been upheld. What is so special about infrastructure? There should be a separate court for infrastructure projects, so that it is disposed of earlier than usual suits. Again, the common man is not taken care of in this legislation.
Thanks, Suresh Kumar.
Thank you.
Thank you, Mr. Parthasarathy. That's been a brilliant exposition of law. We're extremely delighted. There were about 170 participants, and this lecture session was well received. We have certain other questions we're not able to decipher what they really want. And therefore, we will conclude this time with another thanks. Thank you so much. The next session will be on the Transfer of Property Act 1882, law relating to the sale of immovable property. And this will be by your friend, Mr. M.S. Krishnan, Senior Advocate. This will be at 10 o'clock tomorrow. I will request all participants to be present and yeah, hear him. That's what my friend prompts me to say. Thanks so much.
Thank you, Raghu. Thank you, Anand. Thank you, Rashid.
Thank you so much.
Sir, Gopalan sir.
I mean, he's not very computer savvy, and then we may not be able to get him to talk.
Convey my pranams to him.
Thank you so much, and I will certainly convey your pranams to him. Thanks so much.
Thank you.
See you next time in the very same session tomorrow. Thanks.
Bye.